Good morning, ladies and gentlemen, and thank you very much for joining us for our webinar Coronavirus Return to Work, which we are holding in conjunction with Hayes Recruitment. My name is Sibylle Steiner. I am a partner in the employment team of Irwin Mitchell, and I am joined today by my colleague Natalie Flynn. The webinar is going to last for 1 hour. You can ask questions by putting them into the chat box. If we can't answer the questions in the course of the webinar, we will come back to you afterwards and answer the questions that you have raised. At the end of the seminar, there will be a feedback box popping up, and we would be very grateful if you could provide us with your feedback. That is important to us because we're doing these webinars for you, and we would like to hear what are the topics you might want us to talk about and any improvement that we can make. Let's start by looking at the back to work timeline. Probably we all know these dates that you can see on the slides in front of you by heart. We went into lockdown on the 23rd of March. That's 12 weeks ago, and we are now the government has now started the process of getting the economy back to work, and on the 13th of May, the government actively encouraged businesses and employees to return to work if they could not perform the work from home. 1st of June is the date that schools and colleges were encouraged to open for some pupils. Listening to what's been said recently, it is unlikely that all schools will be open or have opened before September this year, though, because it does still seem to be quite difficult to organise a safe place to work and a safe place for pupils to go to. Now, on the 1st of June, again, outdoor markets, car showrooms can open, and more essential shops, non-essential shops, will open from next Monday onwards. That doesn't apply to restaurants or pubs or hairdressers. They may be able to open from July, but that depends on whether it is considered to be safe. What might possibly happen is that there will be local lockdowns depending on whether the R rate increases, so depending on whether there might be local areas where the infection rate increases again. What must a business do in order to be able to open up again? Now, the buzzword here is to be COVID secure. Now, what does that mean? It means that you have to go through a risk assessment to decide whether the business, the place of business, is a safe environment for the staff to work in. Now, there are a number of guidances, sector-specific guidances for England, and again, we've listed a few on the slide, and it is definitely worth reading those to see what sector-specifically has to be done with regard to risk assessments. Now, as an absolute minimum, you would have to follow the Health and Safety Executive risk assessment guidance, which provides that you need to identify what work activity or situations might cause transmission of the virus. You need to think about who could be at risk and then decide how likely it is that someone could be exposed. and then you need to act to remove the activity or the situation. Now, it is not an obligation that you eliminate the risk altogether, now, because that practically will be impossible. But what you have to do is identify the risks and then take the steps to reduce these to the lowest practicable level. Now, the basic rules are that if you can, you need to maintain social distancing. And if that is not possible to maintain within the workspace, then you need to put suitable measures into place to control the risk of transmission. Now, that, for example, could include putting up barriers in shared spaces, or creating shift patterns so that not all the workers work together. And also, please note, if you use shared spaces, so for example, if you share the workplace with other tenants, then you need to liaise with the landlord and with other tenants to identify and minimize the risk. We've got, I think, lots of examples already of what businesses have done in order to minimize the risks. Supermarkets are leading the way there, probably because they have remained open throughout the pandemic. So what have they done? We've all seen that they put up barriers at tills, one-way systems, limiting numbers of people who can enter the shop, and so on and so forth. Now, what I think when you consider opening the office is that if people can still work from home, then you should allow employees to work from home. I think everyone appreciates that that is probably the safest way of dealing with matters, but also, on the other hand, that it might not be possible to keep everyone working from home. And in that case, you need to bear in mind, you need to make the risk assessment that we have just spoken about. Now, putting a risk assessment into place and setting up all these measures is not enough in itself. It's also very important that it is monitored, that these measures are actually being adhered to, because the best system doesn't mean anything unless it is actually followed. One of the questions that we get, or we have received a number of times now, is it necessary for an employer to provide PPE, so to provide masks in the workplace? There is no legal requirement to do that unless, obviously, you work in the hospital or clinical setting, in which case you would be providing those anyway. Now, what about consultation? There are two sets of regulations that might apply in that context, and we've listed them on the slide there. One is the Health and Safety Consultation with Employees Regulations 1996, and then the Safety Representatives and Safety Committees Regulations in 1997. Now, these regulations are designed to enable a business to develop, maintain and promote measures that ensure health and safety at work, and then also to check how effective these are. Now, if you recognise a union and you've agreed to collectively consult with regard to health and safety issues, then you must discuss proposals to make the workplace safe for staff to return with the union representatives. And if you don't have a union representative, then you must consult with your employees directly, either as individuals or through workforce elected health and safety representatives. Now, it might be possible that you have to consult under both of those regulations, and if you're not sure, we suggest that you take advice with regard to that. What does the consultation, what does it look like? And Are there any time limits that you have to adhere to? There aren't any time limits that the law provides, or nor does it say for how long you actually have to consult about returning to work. All the law there says is that you have to do so in good time. Now, what does that mean in practice? It does mean that you have to allow enough time for employees to consider the issues that you're putting to them, and to provide them with informed responses. Now, what is important in this context, again, is that you don't just pay lip service to the obligation to consult, but you really should actively engage. Now, what does that mean? You could send questionnaires to employees to ask them how comfortable do they feel about returning to work, and sort of give them a scale of 1 to 10. Ask whether they want to tell you about any issues they have at home, whether there are any anxieties, and so on and so forth. I mean, clearly you need to bear data protection issues in mind, but it is important for you as a business to find out what problems, what issues employees may have returning to work, because we've been in lockdown for so long, and I think there is a lot of anxiety out there, particularly with regard to employees who have not, who might have either might be vulnerable themselves or live with people who fall into the high risk categories, or have children they need to look after, and so on and so forth. Now, the aim there is to try and resolve the issue. So to communication with employees is relevant, is important anyway, but it's more important, it gets more and more important in the current situation that we are finding ourselves in. So do find a solution by talking with the employees, but please be aware that ultimately you are, as a business, you're responsible for the final decision. And that means that you can't just sort of say, well, we've consulted and people said this, that and the other, but it is the employer that has to make the conscious decision as to what steps to take to bring the risks down to the lowest possible, and as low as possibly. If you do not comply with these regulations, that is actually a criminal offence. So that's worth knowing as well, and health and safety inspectors may enforce them. So they may come and check whether consultation has been complied with. The last bullet point on our slide does say that it is expected by the government that there is that the risk assessment is actually published on the business's website. If with regard or for a business that has at least 50 people, 50 employees, it's an expectation that the government has expressed. And I think it would be advisable, it would be a good thing to do, because also to show the wider world that as a business you take your risk and safety obligations seriously. The next slide deals with issues of travelling. Now that is an really interesting point, because normally as an employer you don't have to factor in travelling to work as part of a risk assessment, but probably it is necessary to do this now. Now we've all seen, well, why is it necessary? Well, we've all seen the pictures of crowded buses and tubes, particularly in larger towns and cities. I mean, in London, commuting, if you have 2 centimeters distance to the person standing next to you, that's a good day. So it's clear that social distancing 2 meters apart on a train or busy bus is impossible to do. Now, therefore, it is our view that as an employer, you should really find out how staff are traveling to work. Now, why is that? Now, you have, as an employer, you have 4 key legal responsibilities. Now, there is the responsibility of health and safety legislation, of course, and there's a common law duty of care, and that means that you have to take reasonable care for the health and safety of your employees. And if harm is suffered by an employee, which is caused or materially caused by employer's actions or omission, and that harm was reasonably foreseeable, and it is fair, just and reasonable to impose liability on an employer, then as an employer you might be liable under that common law duty of care. There's also a duty of trust and confidence, and if that is breached, an employee may claim constructive unfair dismissal. And last but not least, there is a duty not to subject employees to detriment or dismiss them for taking evasive action or for serious or imminent danger. And Natalie will be dealing with that point in a little bit more detail later on. Now, the guidance of the Health and Safety Executive is sort of limited, and it just says that employers should think about how identifying people, how they can travel, can they walk, can they cycle? Well, that's not necessarily the case. I mean, if you live outside London, to walk into the city may take some time. Cycling might also not be an option. So that means that employers should actually actively consider as to how people can come into work if they have to use public transport, for example, have the possibility to wash their hands at entry and exit level, so that they can wash their hands when they come into work and when they leave to work. If that's not possible, to have hand sanitizers, to make it as to reduce the risk. Again, we're coming back to that as much as possible. Also speak to people to ask about their concerns about traveling. Only ask those who are willing and able to attend the workplace to do so if that is possible. We've seen that with some clients, that they have sent emails around to their workforce saying, well, you know, we are planning an opening. Would you find yourself in a position to come to the office? And also to assess each employee's situation individually, to take into account their commute and also their general health, and consider again whether it might be possible for employees to work from home instead. Now, which employees do you have to look at and consider in particular? Now, that's obviously vulnerable people who are not required to shield. Anyone who is shielding should remain at home, and you should see whether it remains possible for them to work at home. Then vulnerable people who are not required to shield, the government there has published a list. Pregnant women, they of course have a right potentially to be suspended on full pay if it's not a safe place to work for them, and also the AME members of staff, because there is increasing evidence that COVID-19 adversely affects that group of people. We won't go into more detail at this point here, but if you need advice there, please let us know. I will now hand over to Natalie. Now, this was a sort of a brief summary of what you need to do to get your staff back to work safely. And Natalie will now be talking about the future and what you need to consider when you have staff or when after staff has come back to work.
Thank you, Sibylla, and good morning, everyone. My name is Natalie Flynn, and I'm a solicitor in the employment team in London and Irvine Mitchell. As Sibylla said, what we're now going to be looking at is the future. I think a lot of people refer to it as the new world post-COVID, and obviously what that can mean for your businesses in terms of bringing people back to work, how you can do that, and potentially obviously looking at keep using that furlough scheme that's already in place. As part of that, we're going to be looking, of course, at the changes that are coming into force from the 1st of July onwards. If you might have to change the terms and conditions of employment, for example, by reducing hours or pay. Also, unfortunately, we're going to be looking at redundancies because we know that that is a reality for a lot of businesses due to the economic downturn that we find ourselves in. And other options as well, such as potentially unpaid leave or sabbaticals that employees could take up. So we're going to look at these different options to see how you as a business can obviously continue to reduce payroll costs in a situation that is currently obviously not an easy one at all. So first of all, we're going to be looking at the furlough scheme. I think most people are already familiar with the furlough scheme as it exists at the moment, and which will continue to apply as it is until the 30th of June. The government announced on the 29th of May that the scheme is going to be extended to the 31st of October. So that's good news for businesses, that the government is going to continue to support businesses with this furlough scheme, which is obviously a very unprecedented government support which has been put in place in response to COVID. But we do need to look at obviously how that's going to change over the next coming months. So from the 1st of July, there's going to be more flexibility in respect of the furlough scheme, which means that employers can ask their employees to come back on a part-time basis, but still remain as part of the furlough scheme. This means that the scheme is going to be changing from the 1st of July onwards. It also means that the government has said that the furlough scheme will be closed to new entrants from the 30th of June. So that means that from that point onwards, employers will only be able to furlough employees that have already been furloughed for a 3-week period before the 30th of June. So this is really important because it practically means that the final date by which employers can actually furlough their employees for the first time will be the 10th of June, which is today. So if you do need to furlough staff, I would recommend that you look into this as a matter of urgency after the seminar, just because that cut-off date is today to be able to introduce new employees onto the scheme so you can continue to benefit from that government support up until the end of October. So, as I said, from 1st of July, there is going to be more flexibility in terms of bringing people back part-time. We don't, unfortunately, yet know a lot about how that's going to work in practice. The government hasn't given a lot of guidance on this yet. However, they have said that they will be giving guidance on this point and on the new scheme rules going forward on the 12th of June, so on Friday. So hopefully by the beginning of next week, we'll have a lot more clarity on what the part return of an employee on a part-time basis means for their pay and how that will work in reality. It will be the case that employers will obviously have to pay their employees for the time that they do return to work, even if that is on a part-time basis. But as I said, at the moment, we don't have enough clarity from the government on how the grant will work into the employee's salary. From August, there are going to be some modest contributions towards the cost of the furlough scheme. And we've summarised on the slide how those modest contributions will look like. So from the 1st of August, the government will continue to pay the 80% of salary subject to the £2,500 cap, but employers will now have to start bearing the costs of the employer's national insurance contributions and also pension contributions. And then from 1st of September, the employer will have to contribute 10% of the salary, and then from the 1st of October, the contribution will be 20%. So with these contributions coming into play, this will obviously have a financial impact on your business, and one that you will have to consider in order to decide for how long you can continue to use the furlough scheme, or if you have to start asking staff to come back to work. So how would you go about if you need staff to return to work? Sabilla's already spoken a lot about the risk assessment, which is obviously a very important aspect. Obviously, you'd also have to inform your staff that you would like them to come back to work. So you have to write to them and let them know about this. You should give them reasonable notice that they are expected to come back to work. Obviously, what does reasonable notice mean? Well, it will depend on the individual circumstances. First of all, you should also check your furlough agreement that you put in place when the employee was actually put on furlough, just in case your letter actually specifies a required amount of notice to be given. That is quite rare, and the template letters that we've produced wouldn't give that minimum notice requirement, but do check what contracts or what letters you've put in place in respect of the furlough scheme. If nothing is said about how much notice you need to give, as I say, it has to be reasonable. You should obviously give your staff as much notice as you can, so that they can also make necessary arrangements, particularly in respect of childcare, for example, bearing in mind that, as Sabilla said earlier, we now know that not all schools will be open to all children, probably into September. The employee may also have another job for which they might have to give notice, so you need to obviously just give them reasonable notice so they've got enough time to be able to return to work as well. They might also raise concerns about coming back to the workplace, and we're going to talk about that in a bit more detail as the next topic. But what you really have to do is essentially inform your staff in writing, letting them know that you're ending their furlough and that you would like them to come back to work. You should also set out any terms and conditions that will apply, and if any of those change, then do seek their consent before imposing those changes. And obviously explain what you've done in terms of your risk assessment to keep the workplace safe, so that the employees feel comfortable returning to work. But as we all know, in reality, there will always be people who potentially won't be able to return to work, or may have concerns about returning to work. This is something that's been coming up more frequently with our clients, and we've been giving advice on this. Because it's a very difficult situation. The government has obviously done a very good job in their stay-at-home campaign, and there is a lot of fear in society about the virus, given how deadly it can be, and the media is obviously a contributing factor to that fear as well. So what's really important is to understand the reasons why certain employees may be reluctant to return to work. And there are some red flags that you should be looking out for in this respect. So, for example, if they're vulnerable, if they're in that vulnerable category, or if they live with someone who is vulnerable or who's shielding, obviously they may have more concerns about returning to work for those reasons. Do you also look at whether or not they may have a disability? And remember that mental impairments can also be a disability under the Equality Act. So anxiety, depression, anything like that will also factor into the definition of disability. Also, if they're pregnant or if they have childcare responsibilities, which makes it more difficult for them to return to work. So do keep an eye out for those red flags and speak to the employees to understand what their concerns are and why they feel uncomfortable about coming back. We appreciate that there will be circumstances where maybe there aren't any particular red flags or reasons, and people just feel worried in general. There's that general anxiety at the moment about COVID. So it's really important to see if you can address those concerns, and that risk assessment is really going to help with that. I've heard of clients who've also been sending their employees videos of the workplace before they return, so they can see what measures have been put in place to make them feel more comfortable about coming back. So that's an option that you could look at, or sending photos of any measures that have been put in place to protect them. And then, as Sibylla said earlier as well, obviously if they can work from home, it would probably be advisable to continue letting them work from home unless that's not possible within their role. Or if they are very concerned about coming back, could you maybe assign them to a different role on a temporary basis to allow them to continue staying at home until the situation is eased up a bit as well. This is going to be something that is going to cause more and more issues for employers. And whilst there will be obviously people who genuinely are concerned, there are also likely to be people who just refuse out of principle as well. So those will be very difficult situations to handle, because you have to balance the genuine concerns with people who just don't fancy coming into work. So that is something that you will be having to deal with. And from a legal perspective, it's something that you have to be very mindful and careful about, because we're now going to be talking about potential cases and claims that we think could come out of these types of situations in respect of forcing people back into the workplace when they feel unsafe to do so. So we do advise that you take advice before taking action, before starting to reduce anyone's pay or disciplining people, just because there are potential cases that are going to be coming and arising from this COVID situation. So we're going to look at those claims, potential claims now that are likely to increase, and they link directly with the with the health and safety rights of employees under the Employment Rights Act. So employees under the Employment Rights Act have a right to not suffer a detriment or dismissal, and if they, in circumstances of danger, the employee reasonably considers to be in serious and imminent danger, and if the employee, as a result of that, either leaves the workplace or refuses to come back to the workplace, or sort of takes appropriate steps to protect themselves, if they then suffer that detriment or they are dismissed because of having raised those issues, there are potential claims that can arise from that under sections 44 and 100 of the Employment Rights Act. This applies to employees, but also possibly the wider group of workers. So do bear in mind that it could obviously have quite a wide impact on your workforce. We think that the current COVID situation is likely to give rise to claims under these sections of the Act, because an employee could argue that they believe to be in serious and imminent danger and then therefore refuse to return to the workplace. And if they then have their pay reduced, for example, or if they're dismissed, then they might try to bring these types of claims. We haven't seen any of these claims yet, so it's very difficult to know what stance the tribunals are going to take. But these claims are quite high risk claims, because they would be automatic unfair dismissal claims, meaning that the employee does not need 2 years qualifying service to bring that claim, and the compensation can be uncapped. Also, an individual could also resign and claim constructive unfair dismissal. So, as I said, these claims are quite high risk, so you do need to be quite careful. The difficulties we have at the moment is that, as I said, we don't have any case law precedent on this yet. there's inevitably going to be a test case on this. I'm sure that no one wants to be part of that. And these type of claims have two separate tests which align with them, and one is an objective test to see whether there was an actual danger. So say we don't know whether the Employment Tribunal would class COVID as that actual danger, but it is obviously a possibility. But then there's also a subjective element as well, which looks at what the employee's reasonable belief is. So that makes it obviously a bit more difficult, because a subjective test will always look at what the employee reasonably believes. So we will have to see how the employment tribunals will start addressing those types of cases. And our recommendation is that the least risky option is, as I said, try to speak to your employees, try to understand what their concerns are, and try to address those concerns rather than just brushing them aside and saying you have to come back to work, or we're not going to pay you, because that could then leave the door open to the employees making these types of claims. If you need advice on this, do come and speak to us. As I say, it is unprecedented. There aren't any previous case laws to sort of look into for us at the moment. So just be aware, if you find yourselves in situations, that it would be best to just seek advice, and we're more than happy to help, of course. I'm now going to hand back over to Sibylla, who's going to talk about changing terms and conditions for employees who return to work.
Thank you very much, Natalie. And as you said, what we are now going to look at is what steps employers, businesses can take if it is not possible to just go back to where business was before the pandemic hit. Can I just say, before I start with that, keep asking questions. We're getting some really good questions in, so please put them into the Q&A box. And we see that we can deal with as many of them at the end of the session, or otherwise, if we can't deal with them during the session, we will contact you afterwards. So, how to change terms and conditions? What changes would you possibly want to make? Would have thought that's possibly in relation to reducing hours, reducing pay, reducing both. And what you need to do in order to be able to do that, first thing is do look at the employment contracts and see whether there is actually an express contractual right that you as the employer have to make the changes unilaterally. Now, ACAS, again, there's a guidance which is worth looking at as well. So they say, well, check the clause, the wording, what you can specifically change. You need to give notice of the change and what process needs to be followed. Now, if an employer wants to rely on such a clause, that clause must be clear and unambiguous. Any ambiguity will be interpreted against the employer, because it would have been the employer who provided that wording. And a note of warning, a general flexibility clause, sort of saying, well, the employer has a right to vary the contract, blah, blah, will most certainly not suffice. Now, even if there is a clear and unambiguous clause in the contract, that still does not give the employer carte blanche, the unilateral right to make the change, because in addition, the employer still has to act reasonably. So what does that mean? Well, reasonably, how long is a piece of string? What it usually means is that you have to give sufficient notice, so you can't make the change sort of saying from tomorrow everyone will have a 50% pay cut. But you have to give notice, you have to think about how to get that across. Now, if it is unlikely, I would have thought, that there is a crystal clear contractual right to make a change, say with regard to cutting hours, changing job duties, reducing benefits, changing location, because those are fundamental terms of the employment contract. And if, as a business, you want to rely on such a clause to make unilateral changes, before you do that, you really ought to bear in mind what risks you will be taking. So if you impose something unilaterally, there is a risk of breach of contract claims, constructive unfair dismissal for employees who have the 2 years continuous service, and possibly indirect discrimination claims. For example, if changes, say with regard to working hours, disproportionately impact on a particular group of employees. For example, with the working hours, that might impact on women in particular with childcare responsibilities. Now, if there is no contractual right to vary, what do you do then? Now, we will be dealing with collective consultation on the next slide. So here is, unless you are obliged to collectively consult, what you need is you need individual agreement with the staff. So again, you need to consult. Now that consultation, again, according to ACA's guidance, should be a two-way process. And that two-way process means that you have to share ideas, you have to work on it together. So as an employer, you should explain the reasons behind it, you should invite employees to talk about the concerns, listen and do everything you can to resolve any concerns. If the changes are agreed, please bear in mind you should confirm that in writing so that you comply with the new Section 1 requirements that came into force in April this year. And if you don't get to an agreement, then you might want to decide to dismiss and rehire, so dismiss and re-engage. Now, that should be a last resort, and again, that should only happen after consultation with the employee. So if you want to consider that, what do you need to do? You need to think about, have I done everything I can to reach agreement? Are the changes I want to happen absolutely necessary? What is the risk to employee morale and engagement? And what is the risk of legal action? If you then still decide that you want to go down that route, you need to follow a fair procedure. So you can't just say, well, I'll terminate your employment contract, here's a new one. You need to follow a fair procedure to do that. You need to give notice, and that's either statutory notice or what's in the contract, whichever is longer. So say if you have employees with, I don't know, 3 months notice period, you need to adhere to that notice. So you can only introduce the new contract, the re-engaged contract, after having given that notice. So it will take some time to come into effect. And you also need to offer a right of appeal against the dismissal. Now, what we mentioned there as the last bullet point is quality and tone of communication is important. So not that anyone would do it anyway, but as a sort of note of caution, to sit down with the employee and say, well, you better agree to this, otherwise you'll be sacked. That's a threat that won't work, and that will be cause for claims raised by employees and can be a basis for a constructive dismissal claim. Now, if you need to consult collectively, now when do you need to consult collectively? And you need to do that in the context of dismissal and re-engagement. Now, the obligation to collectively consult arises where the employer proposes to dismiss as redundant 20 or more employees at one establishment within a period of 90 days or less. Now, the definition of redundancy here and dismissal is wider. So being redundant here is a dismissal not related to individual concerns, to the individual concerned, and it also applies in the context of dismissing and re-engagement. So where you dismiss because you want to offer a contract, say with reduced hours or with reduced pay. And in that context, you are obliged to collectively consult as well. Now, can one go that, be not interested? There is a high financial risk if the collective consultation doesn't happen. There is a risk of the protective award, which is up to 90 days gross, full pay per employee affected. That can get very expensive indeed. And also there is an obligation to notify the Secretary of State if collective consultation is going to be commenced, and if that notification doesn't happen, that is actually a criminal offence. How do you collectively consult with a workforce that is potentially not at work, on furlough, working from home? Now, you need to collectively consult with elected representatives. If you recognise a union, then you would consult with their representatives. But if you don't, then you have to make arrangements for an election for the representatives, and that election should be secret and should be conducted so as to ensure that the votes are accurately counted. Now, as I said, that can get quite difficult where you have people furloughed or at home. So what you need to do is you need to think about how long will it take to set this up. You need to decide how many representatives do you need. You need to ask for volunteers. If you don't have more people volunteering than representatives that are required, fine, you don't need to have an election. If you have more than you think you need, do think about maybe just to appoint all the volunteers so that you do not need to go through the election process. But do take advice if that is something that you are considering. Another thing to consider is that the representatives need to have access to the affected employees. Now, how do you do that when everyone's at home? You need to make sure that they can set up, I don't know, say WhatsApp groups, maybe do it by post, do it by telephone conferencing. And again, it needs to be secure. GDPR concepts need to be borne in mind to ensure that the representatives can consult and can talk to the affected employees in the proper way. Now, all this, I think, as we've mentioned before, will take some time. So we've had some questions from saying, well, what about the special circumstances defence? I mean, could we say this is sort of sudden, unexpected, and therefore we don't need to go through this collective consultation process because it's not possible, it's too cumbersome, it takes too long. Be careful with that. We do know now that the furloughing scheme will change. There will be contributions that need to be made in August. We have the timeline how long the furloughing scheme will apply. So our view is that courts will probably take a dim view if a business now says, well, we don't need to consult special circumstances. Defence is what we're going to rely on. You need to do what you can, and that is our advice. Try to stick with the rules as best as you possibly can. And I think, as I said, because we have the timeline of the furloughing scheme now, it is important definitely to do so. Now we have just very briefly here. There were question marks as to whether employees who are on furlough could actually take part in a collective consultation process. That's been clarified now by the government. It is possible for an employee rep to perform those duties, and it is also possible to consult with furloughed employees about proposed redundancies without breaching these rules. Now, I will now hand over again to Natalie to deal with questions of timing of redundancy and redundancy payments and unfair dismissals.
Thank you, Sibylla. We're now going to look at, as Sibylla said, the timing of redundancy and unfair dismissals in that context. So the existing furlough scheme could be relevant to the issue of whether a redundancy is fair or not. So obviously, if you have a redundancy situation, you still have to have a fair redundancy. And as part of the consultation, when you're going through redundancies, employees in the consultation meetings have an opportunity to raise alternatives to the redundancy. So this raises the point of whether furloughing that employee could be an alternative, albeit short-term alternative, to the ultimate redundancy, and whether you would have to then use that. Our view is that at the moment, where businesses can benefit from the furlough scheme without having to make contributions, there is an argument that using the furlough scheme would be an alternative to making those employees redundant, so it should be considered as part of the consultation process. It doesn't mean that you have to agree to it, because there may be other reasons as to why furlough might not be applicable to your organisations, for example, if you receive public funding. But if it's brought up as part of consultation, then you should give it consideration. And the ACAS redundancy process map also suggests that consideration to the job retention scheme should be given, as the aim of the scheme is to preserve jobs in the short term. Unions, and if you are unionised, are already starting to argue this, that furlough should be used instead of redundancies, so do bear that in mind. However, once the contributions start kicking in from 1st of August, there is an argument that obviously financially it might not be possible for businesses to use the furlough scheme because you would still have that cost. So then it would probably be less likely to have to apply in these situations before going through the redundancy. We just wanted to raise a couple of points on redundancy in respect of notice and also the statutory redundancy pay. So as you probably all know, you still have to pay notice and you still have to pay a statutory redundancy pay if your employees have worked for you for 2 years or more. You are able to serve notice during furlough, and a lot of questions that have arisen in this context is whether that notice pay would be based on the pre-furlough pay or the reduced pay that they received during furlough. It may be possible to base the notice pay on the reduced furlough pay, which will depend on the type of contracts that you have, and it depends on what notice is required to be given under the contract. It is quite a complex area of law, and we recommend that you take advice on that before proceeding to reduce the furlough, before basing the notice pay on the reduced furlough pay. The safest option is, of course, to base it on the full pay pre-furlough, because employees are less likely to then argue that there's been an unfair deduction of their wages and a breach of contract. And if they are successful in arguing a breach of contract claim, then their restrictive covenants would be invalidated. So it's definitely worth taking advice on that. In terms of the redundancy pay, all we want to say on that is that the government has clarified that the furlough grant can't be used to meet the redundancy payments. And again, the same question arises as to whether to base it on the pre-furlough pay or the post-furlough pay, and the same principles apply in terms of looking at what their contracts are, but bearing in mind the risks of employees arguing that there has been a breach of contract if you do base it on the reduced pay. And then just to summarise in terms of what your to-do list should look like, I think priority for today, if you haven't furloughed people yet, but you need to do so, do that today as soon as possible, just because of that change that's coming into force on the 30th of June. Do the risk assessment to make sure that your workplace is COVID secure. Consider the impact of returning to work, and especially those that are vulnerable or shielding. Then obviously, if you need to give notice for people to come back, do so, and prepare your plan in respect of furlough and how you're going to use that going forward. So that is all we're going to say. I'm going to now hand back to Sibylla for some closing words, and then if we have time for a few questions.
Yes, thank you very much, Natalie. I think I need to apologise because for some technical reason I think I might have lost control of the slides. So if that is the case, if someone else could put the slides back to the Q&A and feedback bit, I would be very grateful. Now we have got a few minutes to look at questions that we have received, and I think I will just pick up a few with regard to that. Now let's see, there is got one here. If an employee agrees to the change of terms and conditions, is it still necessary to give the period of contractual notice? No, the answer to that is no. So if you sit down with the employee and they agree, then you do not need to give the notice. So the necessity to give the notice, that applies in the context of dismissing and re-engaging. Thank you very much for raising that question. That's a very important one. Another one with regard to a legal obligation to put, whether it's a legal obligation to put the risk assessment on the website. It's not a legal obligation, it's an expectation that the government, well, it's an expectation by the government. Now putting it on the external website, as I think might help with, also to show that we are, as a business, we're dealing with these things. These are the measures that we are putting into place. And I think it would probably be also particularly important where there is a business with public access as well. Let's see whether we can squeeze another one in. I think questions that have come in with regard to what does it mean that an employee can only continue to be furloughed under the flexible scheme from the 1st of July? Do they actually have to be on furlough on the 30th of June? And the answer to that is that it is our view that it's necessary that the employee was furloughed at some point before the 30th of June. So not the 3 weeks prior to the 30th of June, but at some point between the 1st of March and the 30th of June. So say if you have an employee who was on furlough, say the last 3 weeks in May, and then that employee went back maybe on a part-time basis, that employee has already been furloughed and can therefore take part, continue to take part in the furloughing scheme from the 1st of July onwards. The deadline today, which Natalie mentioned, that is in relation to employees who have not been on furlough at all prior to today. There is also another, I think, in relation to that, to the furlough, important bit of information in the government notes, and that seems to be saying that it is not possible to, from the 1st of July, furlough more people than the highest number of people that you have furloughed before. So by way of an example, if you furlough 10 people, or if so far you furloughed 10 people for 3 weeks and then rotated and furloughed another 10 people, so the maximum number of people you will have furloughed in that case is 10. So you can't suddenly furlough 20 people from the 1st of July onwards unless you have had the maximum number of 20 people before the 1st of July. We are now coming to the end of the webinar, so I would like to say thank you, Natalie, for joining me, and thank you very much for listening. As I said before, we will be dealing with the questions that you have raised afterwards. If you're interested, we do try to update, well, we have our coronavirus hub, and we are putting information in there as quickly as we possibly can when matters change. Do look out, 7 o'clock, probably Friday night. That's the usual time when the government publishes its guidance. So if you don't have anything else to do, look out for that. Otherwise, thank you very much, and thank you very much again for Hayes Recruitment to supporting us and joining us for this seminar, and stay safe and see you soon. Thank you.